Right now, U.S. Marshals are actively moving across the country. Judge Eleanor Caldwell just signed off on arrest warrants for several people, and this all happened because of what everyone's calling the Witness 14 tape that just got leaked. This is honestly the first time in this whole mess of a case that a federal judge has pulled the trigger on immediate custody orders based on testimony that was supposed to stay locked away forever. People who work inside the courthouse are describing absolute chaos. Lawyers are running around panicking, phones are being seized, and marshals are literally stationed at every single exit. This isn't some boring procedural thing or another stalling tactic. This is a federal judge listening to that tape and saying what she heard is clear evidence of serious federal crimes, and she wants people in custody before the sun goes down today. So what actually set off this crazy chain of events? Last Thursday night, a 47-minute recording from a protected witness known only as Witness 14 got leaked online. Within just a few hours, over 2 million people had downloaded it before the platforms even realized what was happening and tried scrubbing it. This isn't just another scandal piled onto a case that's already drowning in scandals. Legal experts are calling this tape the smoking gun, like the piece of evidence that ties everything together. It's got direct recorded proof of coordinated criminal activity with actual names, specific dates, and incredibly detailed descriptions of illegal deals. What makes Judge Caldwell's reaction so different from any other leak we've seen in modern legal history is how fast she moved. She didn't order some long investigation. She didn't schedule a hearing for next month. She verified the tape was real and then issued arrest warrants within 6 hours. Former federal prosecutors are saying they've literally never seen anything like this in modern American law. The people named in those warrants are apparently folks nobody expected to see getting arrested. And the marshals executing these warrants aren't your local guys. They're federal agents taking orders directly from a judge who has clearly seen enough. Let me break down what's actually on the Witness 14 tape. Based on verified transcripts that are now circulating among legal experts and journalists, this recording captures a protected witness describing a full-blown systematic operation to block justice, mess with evidence, and intimidate other witnesses in the case. The witness, whose real identity is still sealed by court order, details how they were personally told to destroy documents, change digital records, and coordinate fake testimony with at least 4 other people. The tape has specific dates, March 14th, April 2nd, and May 19th of this year. It names 3 co-conspirators who weren't previously identified, and it describes cash payments totaling more than $340,000 that were handed out specifically to keep potential witnesses quiet. Legal analysts who've reviewed authenticated parts of this recording say the level of detail is absolutely staggering. The witness apparently says something like, "I was told exactly what to say. They literally gave me a script. When I asked what would happen if I didn't go along with it, they made it crystal clear that my family would face serious consequences." This wasn't normal witness preparation. This was straight-up witness tampering on a scale that prosecutors are calling racketeering. But here's where it gets even crazier. The tape also has Witness 14, describing a meeting where they talked in explicit detail about destroying evidence. The recording includes the witness explaining how documents got shredded, hard drives were wiped clean, and cloud backups were systematically deleted, all while the investigation was actively happening and subpoenas had already been issued. A former federal prosecutor named Marcus Webb told reporters that this recording is the clearest documented evidence of obstruction he's seen in 30 years of practice. The specificity is what makes it so devastating. The witness isn't speaking in vague terms. They're providing badge numbers of people allegedly involved, physical descriptions of locations where illegal meetings happened, direct quotes from conversations they were part of, banking information connected to alleged payoffs, and names of attorneys who allegedly helped facilitate the whole scheme. And it gets even worse. The final part of the tape reportedly has Witness 14 describing actual threats made against their own children. The witness says photographs of their kids' school were sent to their personal phone with a message that read, "Testimony has consequences." A professor at Georgetown Law named Danielle Reeves pointed out that this takes the charges to a whole different level. Threatening a witness is obstruction, but threatening their children is witness intimidation at its absolute worst, which is a separate federal felony that usually comes with enhanced sentencing. The whole tape runs 47 minutes. Legal experts note that roughly 31 minutes contain directly incriminating testimony, with the rest covering procedural questions from the interviewing attorney. The recording quality is apparently exceptional, clear audio with no gaps or signs of editing. Multiple authentication experts have confirmed the tape appears genuine. The vocal analysis matches previous verified recordings of the witness. The metadata shows the recording was made on the date claimed, and references within the tape to outside events have been confirmed by independent documentation. Sources close to the investigation say Judge Caldwell personally reviewed the entire tape before issuing her orders. According to courthouse sources, she watched it twice, only pausing to consult with her clerks about applicable laws. The transcript excerpts that have leaked are damning enough, but people who've actually heard the audio describe something even more powerful. You can hear the witness's voice, the fear, the exhaustion, the resignation of someone who knows they're putting everything on the line. One journalist who got hold of the tape described it as 47 minutes that will completely redefine this entire case and possibly this whole era of American justice. Now, let me tell you how we even got here, because it makes this revelation even more devastating. This case has been building for over 2 years. What started as a routine financial investigation slowly expanded into what prosecutors are now describing as a massive criminal enterprise involving fraud, corruption, and systematic obstruction across multiple jurisdictions. Tensions had been ramping up for months, with repeated delays, sealed motions, and the mysterious withdrawal of 3 previous witnesses who suddenly claimed they couldn't remember things when testifying under oath. Legal observers were getting increasingly frustrated watching what looked like a case slowly dying from procedural strangulation. Everything changed on October 3rd when Witness 14 first entered protective custody. According to court documents, Witness 14 was an insider, someone with direct knowledge of how things operated, who initially cooperated with the defense before dramatically switching sides. Prosecutors moved them into witness protection within 48 hours of their decision to cooperate, citing credible threats. For months, Witness 14's testimony stayed sealed. Defense attorneys filed 17 separate motions trying to access the recordings. 17 times, Judge Caldwell denied them, citing ongoing security concerns and the witness's protected status. This wasn't about protecting some legal strategy. This was about protecting an actual human life. On November 8th, the defense filed an emergency motion claiming prosecutorial misconduct, alleging that Witness 14's testimony had been forced or coerced. Judge Caldwell scheduled an evidentiary hearing for December 2nd. That hearing never ended up happening. On November 29th, the tape leaked. Anonymous accounts on encrypted platforms started distributing fragments of it. Within hours, the full 47 minutes appeared on multiple hosting sites. By midnight, it had spread beyond any possibility of containment. Judge Caldwell called an emergency session at 6 in the morning the next day. Courthouse sources described her as visibly furious, not about the content of the tape itself, but about its unauthorized release. She reportedly told the assembled attorneys that the leak itself is a federal crime, but the contents of this recording constitute crimes of far greater magnitude. By noon, she had issued the arrest warrants. What makes this case unique isn't just the alleged crimes, it's the documentation. Usually, obstruction cases rely on circumstantial evidence, conflicting testimony, and complex forensic reconstruction. This tape provides something prosecutors almost never get: a direct witness describing criminal conduct in real time with specificity that leaves virtually no room for alternative interpretation. The bombshell moment came at 11:47 in the morning when Judge Caldwell took the bench for her emergency session. Attorneys for both sides had been summoned with less than 4 hours' notice. Some showed up still pulling on their suit jackets. Others clearly hadn't slept. The gallery, which is normally restricted anyway, had been completely sealed. No press, no public, only essential personnel. Courthouse reporters positioned outside described this eerie silence, and then marshals started taking positions at every entrance. Deputies who normally patrol the parking structure got reassigned to interior corridors. When Judge Caldwell finally spoke, witnesses say her voice carried a weight they'd never heard before. She reportedly began by saying she served on the federal bench for 22 years, and she has never encountered evidence of witness intimidation this explicit, this organized, or this contemptuous of her court's authority. The courtroom went completely silent. Defense attorneys reportedly exchanged glances. Then she read the names one by one. 4 individuals, arrest warrants signed and sealed. When she finished, she looked directly at the defense table and said something like, "If any officer of this court had knowledge of these activities and failed to report them, They should consider their own legal exposure very carefully in the coming days. Two attorneys immediately asked to withdraw from the case. Judge Caldwell denied both motions, citing the ongoing investigation. That's when it became clear this isn't just another case falling apart. This is a federal judge declaring war on obstruction itself, with the full weight of the U.S. Marshal Service backing her authority. This isn't the first time a leaked tape has destroyed a legal defense, but the speed of the judicial response sets this apart from every modern precedent. Think back to Watergate. When the Nixon tapes finally came out, they revealed a president directly coordinating obstruction from the Oval Office. But that revelation took years of legal battles, congressional investigations, and a Supreme Court ruling forcing their release. The system moves slowly, methodically, carefully. When the Access Hollywood tape leaked in October 2016, it exposed conduct that would have ended most political careers, but there was no judicial response because there was no active case. The tape existed in this legal vacuum. The key difference now is Judge Caldwell isn't waiting. The Martha Stewart case probably offers the closest parallel. Stewart wasn't ultimately convicted for insider trading. She got convicted for obstruction and lying to investigators. The cover-up proved worse than the original crime, but even that case took months of deliberation before charges got filed. Here, Judge Caldwell moved from tape verification to arrest warrants in 6 hours. Legal historians are already comparing this to the Saturday Night Massacre of 1973, when Nixon's attempts to obstruct the Watergate investigation led to dramatic resignations and ultimately his own downfall. The parallels aren't perfect, but the underlying principle is identical. The obstruction itself becomes the central crime, overshadowing whatever was being hidden. The pattern is clear. When recordings emerge that document criminal conduct in real time, the cover-up consistently creates more legal trouble than the original offense. Now, however, we're seeing something new, a federal judge treating obstruction not as a secondary charge to tack on later, but as an emergency requiring immediate law enforcement response. Judge Caldwell has essentially declared that the integrity of the judicial system itself cannot wait for normal procedural timelines. That's unprecedented, and it may completely reshape how federal courts handle evidence tampering and witness intimidation for decades to come. Legal experts are calling this a watershed moment for judicial authority. A former U.S. attorney who now teaches at NYU Law told reporters that Judge Caldwell's actions represent exactly what courts are supposed to do when confronted with clear evidence of obstruction: act decisively to protect the integrity of proceedings. He emphasized that the speed wasn't reckless, it was necessary. When you have witnesses being threatened, evidence being destroyed, and testimony being coordinated, every hour of delay allows more damage. Judge Caldwell understood that waiting means losing. Meanwhile, a constitutional law professor noted that the judicial authority to issue arrest warrants based on leaked evidence raises some complex questions, but ultimately supports Caldwell's decision. The source of evidence doesn't determine whether it can be used or how much weight it carries. The leak was illegal, sure. The conduct documented on the tape was also illegal. The judge has an obligation to respond to both, but the greater crime clearly takes priority. A former federal public defender offered a more cautious perspective. Defense attorneys are definitely going to argue that this tape was illegally obtained and should be inadmissible. That's a legitimate legal question. But the arrest warrants aren't based solely on the tape. They're based on the judge's finding that ongoing criminal conduct requires immediate intervention. A criminal justice expert at NYU Law School added that targeting witnesses' families represents an especially serious escalation. Threatening children crosses every possible line. It transforms witness tampering into something closer to domestic terrorism. Federal sentencing guidelines treat this as an aggravating factor that can add years to any eventual sentence. Even former prosecutors who typically advocate for deliberate, methodical proceedings have supported Caldwell's response. One former DOJ official admitted that in normal circumstances, you'd want to take more time. But these aren't normal circumstances. You have a protected witness whose family was threatened. You have evidence being actively destroyed. The judge faced a choice: act now or watch the case collapse. He noted that Judge Caldwell's reputation for meticulous, by-the-book legal work makes her response even more significant. This isn't a judge known for dramatic gestures. Eleanor Caldwell has spent 22 years building a reputation for patience and precision. When she moves this fast, it tells you exactly how serious this situation is. The consensus among legal observers is striking. Regardless of political perspective, the evidence on that tape demands an immediate response, and Judge Caldwell delivered it. So, what does this actually mean going forward? First, the immediate legal exposure for those named in the warrants is absolutely staggering. Federal obstruction charges carry statutory maximums of 20 years per count. Witness tampering adds another 20 years. Threatening a witness's family members creates additional charges under federal intimidation statutes. And if prosecutors can establish coordination among multiple defendants, RICO provisions could multiply the sentencing exposure exponentially. This puts everyone named on those warrants in an impossible position. On one side, fighting the charges means discovery, which means prosecutors get access to communications, financial records, and testimony from additional witnesses. On the other side, cooperation means implicating others, potentially including individuals with significant power and resources. Neither path offers any safety. Second, the professional consequences extend way beyond prison time. At least 2 attorneys have already tried to withdraw from the case, and legal ethics experts suggest more will follow. Any lawyer who knew about the obstruction scheme faces potential disbarment and criminal liability. The tape apparently references legal counsel facilitating witness coordination. If those references prove accurate, the defendants may find themselves unable to get experienced representation. Bar associations in 3 states have already announced preliminary ethics investigations. The American Bar Association's Standing Committee on Professional Discipline is reportedly monitoring the case closely. Third, the long-term implications for judicial procedure could reshape how courts nationwide handle obstruction allegations. Judge Caldwell has established a precedent. When evidence of ongoing obstruction emerges, courts can and perhaps must respond immediately rather than allowing procedural delays that enable further criminal conduct. This matters because obstruction cases typically move slowly. The standard approach involves methodical investigation, grand jury proceedings, and careful charge construction. What Caldwell has done is essentially declare that some circumstances don't permit that kind of deliberation. When witnesses are being threatened and evidence is being destroyed in real time, the court has both the authority and the obligation to step in immediately. The implications for the rule of law itself are profound. For years, critics have argued that powerful defendants can obstruct justice with impunity, using delay tactics, witness intimidation, and evidence destruction to prevent accountability. The standard judicial response has been patience, process, and deference to procedural norms. Judge Caldwell's actions represent a different model: aggressive, immediate judicial intervention when obstruction threatens to defeat justice entirely. If other federal judges follow her lead, we could see a fundamental shift in how the American legal system handles defendants who attempt to corrupt proceedings. The message would be clear: obstruct at your own peril, because courts will no longer wait politely while you destroy the case against you. The coming weeks will determine whether Caldwell's approach becomes a standard template or just an outlier. But for now, her actions have demonstrated something many Americans had honestly begun to doubt. The system can move quickly when judges choose to make it move, and then the defense made everything even worse. Within hours of the arrest warrants becoming public, attorneys for one of the named individuals released a statement calling the judicial action a grotesque abuse of power driven by illegally obtained evidence. Instead of addressing the actual contents of the tape, the specific allegations of witness tampering, evidence destruction, and family intimidation, the response focused entirely on the leak itself. The statement read something like, "This court has abandoned any pretense of impartiality. Our client will fight these politically motivated charges with every legal resource available." Social media accounts associated with the defense started amplifying a new narrative. The tape was fabricated, the witness was coerced, and Judge Caldwell had been compromised by prosecutors. The problem with that response: it addresses absolutely none of the documented facts. A legal communications expert pointed out the obvious flaw. When your defense is attacking the messenger while completely ignoring the message, you've essentially conceded the message is true. They're not saying the witness lied. They're not providing alibis for the dates mentioned. They're not explaining the payments that were documented. They're just screaming about how the evidence became public. The response also created new legal exposure. By publicly attacking Judge Caldwell's impartiality, the defense may have handed prosecutors additional ammunition. Statements suggesting judicial bias can actually be cited as evidence of consciousness of guilt. Defendants who know they're guilty often attack the system rather than address the actual evidence. Meanwhile, the other named individuals have stayed completely silent. Their attorneys have declined to comment, issued no statements, and made no public appearances. Legal observers note that this silence may indicate active plea negotiations or simply recognition that speaking publicly can only make things worse. Perhaps most damaging, not a single voice has emerged to contradict Witness 14's specific claims. No one has denied the meetings occurred. No one has denied the payments. No one has explained why photographs of a witness's children's school would show up on their phone. When your response to 47 minutes of documented criminal conduct is just, "The tape shouldn't have leaked," you've already lost the argument. The court of public opinion has reached its verdict, and the legal courts are now moving to reach theirs. But beyond the immediate legal fallout, this is really about something much bigger. This is about whether powerful people can corrupt the justice system and escape accountability. It's about whether witnesses who risk everything to tell the truth will actually be protected or abandoned to face threats against their families alone. Witness 14 didn't leak that tape. They trusted the system. They entered protection. They told the truth under oath. And someone with access to sealed court records betrayed that trust. But the betrayal exposed something the system had failed to stop: months of obstruction, coordinated witness tampering, threats against children. If this goes unanswered, it signals that testimony is worthless, that witnesses who cooperate will be hunted, that evidence can be destroyed with complete impunity as long as you have enough resources and enough ruthlessness. Judge Caldwell's response represents a different choice. It says the system will fight back. It says obstruction will be met with immediate consequences. It says witnesses who come forward will be protected, not just by marshals, but by the full coercive power of federal courts. This affects every American who might someday need the justice system to actually work. And finally, it appears to be working. Here's where things stand right now. U.S. Marshals have confirmed that 2 of the 4 individuals named in the warrants are in custody. A third was apprehended at a private airfield approximately 90 miles from the nearest international border, traveling with 3 suitcases and over $40,000 in cash. The 4th individual remains at large. Marshals have issued a public advisory indicating they may have fled the jurisdiction. Federal agents are now coordinating with international law enforcement. According to sources close to the courthouse, Judge Caldwell has scheduled an initial appearance hearing for tomorrow morning at 9 a.m. The 2 individuals already in custody will be arraigned. Bail arguments will be heard, and prosecutors will present their case for continued detention. Legal observers expect prosecutors to argue for detention without bail, citing the explicit evidence of witness intimidation and the apparent flight attempt by the 3rd defendant. Meanwhile, Witness 14 has reportedly been moved to a new secure location. Sources indicate their protective detail has been doubled, and communication with anyone outside the protection program has been completely suspended. The tape itself remains widely available despite platform removal attempts. Legal experts note that its distribution cannot be contained, meaning every potential juror in the country has likely been exposed to its contents. Defense attorneys will almost certainly argue for venue changes, though given the national coverage, finding an untainted jury pool may prove impossible. Keep a close eye on tomorrow's hearing. Bail decisions will signal how seriously the court views the flight risk, and any plea negotiations, if they begin, could break open even more explosive revelations. The next 48 hours will be decisive. The system is finally moving. Now we see how far it goes. The stakes have never been clearer. The evidence has never been more damning. A federal judge has watched 47 minutes of documented obstruction and responded with immediate arrest warrants. Marshals are executing those warrants right now. What happens next will determine whether this represents an actual turning point, a moment when the justice system proved it could still function, or just another case that slowly drowns in procedural delays. This isn't just another scandal. This is the system being tested. And so far, Judge Caldwell is passing that test.
Yeah, grind mode on, can't kill my drive. Turn the pressure up, I come alive. Grind mode on, I don't fold, I don't quit. Hunger in my chest, every beat I commit. Eyes on the prize, no sleep till it's won. World in my hands when the grind mode's on. Wake up with a vision, I'm locked on the target. Turn pain into fuel, I'm a flame, I spark it. No shortcuts here, I embrace every test. Pressure on my shoulders, still I handle it best. I was made for the climb, every loss, every scar built me in the steel, now I shine like a star. If the road gets rough, I just double my speed. Ambition on 10, I was born to lead. Grind mode on, I don't fold, I don't quit. Hunger in my chest, every beat I commit. Eyes on the prize, no sleep till it's won. World in my hands when the grind mode's on. They said limits exist, but I shattered the frame. Every wall in my path is just fuel for the frame. Discipline heavy, but my spirit is free. I don't chase success, success chases me. I'm the storm and the calm, I'm the rise, I'm the proof. Every bar that I drop is the grind in the booth. Blood, sweat, tears, that's the code I trust. I don't wait for the crown, I earn it, I must.